Hi again, people. Well, let's talk about a couple legal issues and subpoenas and the ATF and the government. So, this guy is CRS Firearms. I think his name's Matt. That's what he put in the email. But when we were talking on the phone, he said something about people know him as Mike or Matt. I can't remember. Anyway, so I don't know a whole bunch about his case. What I do know, I'll share, and if I get it wrong, well, I tried. So CRS Firearms, evidently he took on, from my understanding, a sponsorship from the guy that made those little key cards. The ones that supposedly you pop out the little thing and you can put it in your AR or something. So he didn't produce them, he didn't possess them, he didn't sell them. He just simply, they paid him to promote or to sponsor, and I guess he either mentioned them or whatever. I'm not even sure on how the sponsorship worked with him. Anyway, he got caught up with this guy, and now the ATF is harassing the guy. I think his name's Chris. Here's the fundraiser for this guy, because the ATF evidently is going after him. And again, I don't even know what this guy did. So there's all kind of legal things. I'm not discussing this case per se. I'm more discussing what they're kind of doing to this guy, Matt. So he did this video. Oh my God, is on. He came home and the ATF was at his house. And they were serving him a subpoena, or serving his wife a subpoena. So evidently his wife set up a GoFundMe account for this guy when the feds went after him. And now the feds show up and serve her a subpoena. And I've talked about subpoenas before. A subpoena is normally issued by the DA, by any assistant DA, actually. So as a DA, if I file charges, let's say I file charges, I'm a DA, and I file charges on this guy. I don't need to go to the court and ask for a subpoena, and I don't need a search warrant. As a cop, it's easier if a DA issues a subpoena than me getting a warrant. Because when I get a warrant, I have to write my probable cause. I have to set up my, my hero sheet on why I think I'm credible. Then I have to prove why my probable cause thinks I'm going to find evidence. Then I have to run that by a DA. A DA has to sign off on it. Then I have to take that to a judge. A judge has to read it, and he has to sign off on it. I got to file it with the court. Once it's filed with the court, then I can go serve it. So it's a pain in the ass to get a search warrant. Well, a DA merely takes out a subpoena sheet and signs it, has an officer of the court, and it's just the same as a search warrant. So subpoenas are much easier to get and to hand out. Now, for a DA, at least in California, the DA can't issue a subpoena unless charges have been filed. If charges haven't been filed, then they need to get a cop to do a search warrant. Now, DAs don't do search warrants. A lot of people see that shit on TV. So, DAs and prosecutors and lawyers do not do search warrants. Peace officers or cops do search warrants. DA may approve it because they're going to have to defend it, but a DA can't be a witness in their own case. So a DA can't fill out a search warrant and say, I certify and I'm an affidavit, etc., because now if they do a search warrant, the defense can subpoena or put that DA on the stand and say, hey, you did a warrant. Just like they do if I do a warrant as a cop, the defense attorney gets me on the stand and goes, did you write this warrant? Was everything in the warrant true? You said here, blah, blah, blah. What did you mean? You said you interviewed this witness. What did this witness say? So a prosecuting attorney is not supposed to be a witness in their own case because they don't want to have to get on the stand. So when you see TV or you think that attorneys write warrants, it's not true. They may write the meat of a warrant for cops that don't know how to warrant. I know in Illinois, my buddy's a state trooper there, and when they need a warrant, they just go to state's attorney, and the state's attorney types it up and asks them questions, blah, 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 blah. I think that's a legal issue, personally. I mean, the cop didn't even write the freaking warrant. He basically allowed the state's attorney to write the warrant, type the warrant, then give it to the cop, and then the cop signs it, has his own, and he presents it as his own. I kind of think that's bullshit, and there should be some legal challenges in Illinois, but whatever. I know a lot of agencies that don't know how to write a warrant, so the DA ends up writing it because it's easier than trying to explain to the cop how to write it, then reviewing it, correcting it, and doing all that. DAs just go, screw it. I'll just type it. I'll ask you questions. We'll make it look. I'll write it as if you're a perfect person. You sign it as if you wrote it, if it's true, and then we'll go from there. And I'll do the same thing if I'm trying to get somebody a conviction. If I know a guy's guilty and he's talking to me, I will say, okay, you told me all this. I'll interview him. He'll tell me some incriminating statements. I'll take notes, and I'll say, hang on a minute. I'll go type up a statement for him on what he just told me. I'll hand it to him and say, okay, I typed out your statement. I want you to review it, make any corrections, and tell me if I got it wrong. But is this what you told me? He reads it. He goes, yep. I said, everything in there is true? Yep. Would you mind signing that? That's a signed confession. You don't get much better than that. So now that I've kind of gone in all those legal areas, let's get to the subpoena area on why this guy, I want you to understand how subpoenas are issued. Now, when a grand jury convenes, a grand jury is a fact-finding body. It finds facts. It's either finds facts through subpoenas or through their own investigation or through a DA or a state's attorney presenting a case to them, which is presenting all the facts, and then they decide whether to indict or whether criminal charges, whether they think there's probable cause or there's enough to indict somebody. Not all jurisdictions use grand jury. Now, feds, they use grand jury sometime, but they don't necessarily need to use the grand jury. You don't have to go to the grand jury to get an indictment. So in this case, his wife sets up a GoFundMe for this guy because he's, he's a sponsor. They know him. They want to help him out. He's a gun guy, and they're trying to help Second Amendment and help people, because the government comes after you. They want to take your money, seize, lock up everything so you can't defend yourself. So you end up getting locked into this, I'm facing charges, I'm facing life. They seize my money. They seize my home. They seize my assets. They cost me my job. I can't even make money to defend myself. They won't give me a public defender because they say I have a house or assets, so I have to go completely broke in order to defend myself or take some bullshit plea or take my chances in court. So the feds have the deck stacked against you. That's not the way the founders wanted it, but it doesn't matter. Our government's out of control. So they have charged the guy making a key card, and somehow they've connected his wife to the case. I don't know. Like I said, I don't know enough about the case to understand what they did, what their involvement, what their conversations were, what their agreement was, what they signed. I have no idea how they're connected to this case. But the fact that the case is happening, I think, in Florida, and I don't know where this guy's at. He said he's across the country, so I don't even know where CRS is at. I mean, I've seen a couple of videos that people have sent me and said, hey, watch this guy. He's talking about this or he's talking about that. Or I think I asked a question about a key card. Somebody might have sent me to his video. And I don't know if I watched it or not because I still don't understand how that little key card punch-out thing works. But let's stay with the legal shit. So his wife gets subpoenaed by the feds. ATF agents show up to his house and serve his wife in person. Now, the thing about subpoena is it has to be good service. So normally a cop delivers it. So if I was serving, let's say I want some medical records, and I go to the hospital and I go, hey, I'm working a case on this homicide or on this child abuse or on this domestic violence or on this rape, and I need to get some medical records from this. Well, we can't release that without a warrant. Okay. So then I would go back to DA and go, hey, hospital's being a dick. They don't want to give me the shit. They're calling HIPAA and all this other crap. I need a subpoena or a warrant. Can you hook me up a subpoena because it's easier? And the DA goes, sure. She pulls out a subpoena form. She puts on there medical records, all records relating to this case, and she signs it as an officer of the court, or he signs it as a DA. He signs it, and that's just as good as a warrant. Now I go back to the hospital and I go, here's your warrant. They go, well, this is a subpoena. I go, same thing as a warrant. It's a court order. A warrant is a court order. A warrant is something I take to a judge signs it, and now it becomes a court order. A subpoena is a court order. The only difference is instead of a judge signing it, a DA signs it, has an officer of the court, and it's just like the judge signed it. You have to comply or you're in contempt. Now, you'll probably get more trouble for stopping or failure to comply with a search warrant than a subpoena. A subpoena, I mean, they still might hold you in contempt, but the DA has to get you in front of the judge and go, I issued this, and they're hindering prosecution, they're refusing to comply. and they didn't show up, etc. There was one case to where a girl, like in all DV cases, they call the cops, they want their husband arrested, he's the worst piece of shit in the world, we take him to jail, and then when it comes time to trial, they've made up, they don't want to get kicked out of their house, the husband's gotten back with them, and now they love each other again, and the woman says, I lied on my statement, and I don't want to testify. Well, the prosecutions have decided they used to just dismiss the case, and now they're like, no, you don't have a choice. You gave a statement, we're going to put you on a stand, either you're going to lie, or you're going to say you're not going to testify, and then we're going to get to read in your statement you gave. So either way, we're getting it in. And that's how they're kind of playing hardball more. Now, of course, the women activists are all pissed off saying, that's not fair. You're re-victimizing the poor woman. She was already victimized by the man. Now you're picking her court. You're making her... Bullshit. She freaking cried wolf. She called the cops. She shouldn't have called the freaking cops. If she calls them, tough shit. So anyway, there was one case to where this girl did this shit, and we were in court, and the judge literally looked at me and goes, Detective Gore, do you know where this woman lives? I go, yes, sir. I went to their house, blah, blah, blah. He goes, go to her house right now. I'm ordering you to bring her in front of me forthwith. Use all force necessary. And I went, you want me to kick the door if she don't answer? Use all force necessary. I'm ordering you to go bring her in front of me. And I went, okay. So I go to her house and knock on the door. And she's in there. She's like, I'm not testifying. I go, you don't have a choice. The judge just ordered me to come get you. She's like, I'm not testifying. I go, if you don't come out, I'm going to have to kick the door and arrest you and bring you in handcuffs in front of the judge. I have to bring you. I have a court order. I need to see the warrant. Well, I don't have a warrant because warrants can be oral, written, or verbal. And the judge basically, by telling me that, gave me an oral order. It's the same thing as a written order. It's on the record. He did it in an open court. The stenographer typed it out, and it's a court record, and I have an order to go do it. A judge can sit in a bar and see a cop and say, I am a sitting judge, and I'm ordering you to arrest this person right now. And that is just like a court order, etc. So, and that gets into a lot of other peripheral issues. We won't get into that. So anyway, I end up kicking the girl's door in and putting her handcuffs, and she's fighting me the whole way and brought her into court. And I kind of thought it was bullshit, but... you know, it was all legal and we did what we had to do. So in that case, it was a personal thing for the judge and he wanted this woman in there. He didn't want to play with her. In a subpoena, you're being ordered in by a DA or a U.S. attorney. In this case, because the Fed served it, I figured it was a federal case. So the ATF's involved, and most subpoenas are served to where the witness is readily available. It's usually within the jurisdiction of the county. In this case, because this is in Florida, and he's saying he's literally across the country, so I don't know if he's in California or whatever, but he says he's literally across the country. She has to fly there. There's all kind of issues that there's ways to get out of subpoenas. You just can't get out of a subpoena by saying, screw you, screw the court, I ain't testifying. Because then they'll get you for contempt. And then the judge will issue a bench warrant and say, go arrest this person and bring her in front of me. And then they will arrest you and put you on a bus, and it may take 3 weeks to get there, and they will inconvenience you, and they will screw you over, like I talk about my child abduction where we had to get that mother, the grandmother from Florida, all the way back to California, and instead of flying her, they put her on buses, and it took like 3 days. And I thought it was kind of bullshit, but whatever. Anyway, and I thought she was a pain in the ass, so I wasn't really too concerned. But anyway, the subpoena thing is really... something that you need to understand. It's kind of like a court order. When you violate a court order, you can be held in contempt. Now, people violate court orders every day. They violate child custody order. That's violation of court order. But the courts don't really take offense to it. They just let people get away with it. So violating a court order is only as serious as the person wants to make it that issued the order. So when a U.S. attorney subpoenas you, if they really want to make a point, then they can say, you know what, she didn't show up subpoena, go arrest her. Go to the judge, she'll go to the judge, go, I served a subpoena, it was served on this day, and the person failed to show and did not notify sitters. Now, if the person has an attorney or even writes a letter themselves saying, hey, you guys subpoenaed me, you gave me, I think in this case they gave them 8 days notice, which is pretty short notice, to travel all the way to Florida to make airline tickets, etc. I mean, there's hardships that people have lives, and if you have medical issues, if you have child care issues, if you have, you know, you're taking care of an elderly person, you have physical limitation, you're stressed out, you're sick, there's ways that you can say, hey, I'm not able to make this subpoena. And if you notify the court that you're not able to make it, then you're less likely to be held in contempt. Now, if you call them and go, hey, I stubbed my toe and it hurts, I ain't coming, then they're probably going to hold you in contempt. But if you have legitimate reasons and you articulate it well, you can get out of a subpoena. So in this case, his wife is breastfeeding. It's in the middle of COVID. They're running a business. She has to get on a plane. Now, of course, the feds told her, we're going to give you a voucher for the plane ticket, so it's not going to cost you anything, and we're going to pay you $40 a day. $40 a day is what the feds want to pay you. Now, if you're freaking on unemployment, you get like freaking $200 a day. I don't know what they're paying, $700 a week or some shit on unemployment. But if you're going to testify and we're going to inconvenience you and make you go under threat and harassment that you can go to jail if you don't comply, we're going to say we're going to give you $40 a day. That's barely enough to freaking eat for a day, especially if you're traveling. So, I mean, it's total bullshit. But they served her with a subpoena. And according to Matt, the only thing that she did was set up a GoFundMe for this guy. That's the only thing she did. To me, that doesn't pass the smell test from my investigator. I'm not saying he's lying. He may think that's the only thing. That doesn't pass the smell test that an attorney would waste time subpoenaing and spend money and funds and have call across the state and have ATF agents in another state serve somebody in order to get them to Florida only to testify that I set up a GoFundMe account. That doesn't make sense to me. The feds want more, in my opinion, from her. They think, or they suspect, or the other person has said, or they've tapped phones, or they have documents that this girl either conspired, talked, encouraged, advised, did something to assist this person they're charging in their crime. That's what I think, just from the limited, and I have very limited. I mean, my whole information is I watched this video. Oh my God, it's on now. I watched this video and I talked to him and he told me the only thing my wife did was set up the GoFundMe. And he had a sponsorship. So to me, that doesn't make sense that the government would see them as a critical witness. There's other ways to prove that if I want to do it. Now, they're subpoenaing them not for a court trial. The grand jury, they're subpoenaing them for a grand jury, which tells me the state's attorney is presenting a case to the grand jury trying to get an indictment on this guy that's making those little, whatever they are, automatic key card punch out, make your gun on automatic key card punch. They are trying to charge this guy. And somehow they think his wife, who set up the GoFundMe, is a critical piece of information that will make their case stronger in front of the grand jury. I just don't see how that one fact is going to do that. I mean, it's pretty easy to prove that there was a GoFundMe set up. They can subpoena the records. They know where the money was sent. They know who collected it, and they know who set it up. And they can present that to the grand jury through documents. Why would they want to drag a woman who is breastfeeding a child halfway across the country in the middle of COVID to testify that I set up a GoFundMe account? It doesn't pass the smell test to me. So, my advice would be they have an attorney, and the attorney should try to get this subpoena either quashed, and I use, a lot of cops say squash it, meaning get rid of it. But it's technically with a Q, it's quash, it's to suppress or stop or something. You can look it up, it's a legal term. I've covered it in some other documents. But you can quash a subpoena through a letter by saying, it's too broad, my client doesn't have anything to say, my client's going to take the fifth when he gets there, so me coming is really a moot point. Why do you want to drag my client with her baby, endanger her baby, expose them to COVID, inconvenience them, cost them financially? They're running a business. Why? What is the purpose of my client showing up if her only statement is going to be, I take the fifth? Now, anybody can take the fifth. However, as the prosecutor, she can offer immunity to her and say, you're not going to be charged for anything you say here, therefore you have to testify. You cannot take the fifth. Now, if that's their plan to stop her from taking the fifth, they must have more information, or they want more information from her. So, I mean, I hope they're communicating with their attorney well. I hope they understand that any conversation they had, and I told them, I said, look, make sure your wife understands that nobody has a perfect memory. When you're on the stand, you need to testify and use terms such as, to the best of my recollection, or from what I remember, or I think, or, you know, I'm not 100% sure, but I think this is what's said. Even as a cop, I testify that way because I know I'm working a lot of cases. I have a lot of players, a lot of witnesses, a lot of DAs, a lot of people, you know, whatever. I got a lot going on, and it's easy for me to misspeak or you know, to misquote a fact or to say something. And if I say something that's absolute that I know is true, technically, if the government can prove that it's not true, then I committed perjury. So by using terms like, to the best of my recollection, this, from what I remember, this. So when you're testifying, you need to make sure in terms that you use that. Now, the problem with using terms like that is the DA knows it leaves you wiggle room, so they try to lock you down. And they will try to say, well, does this refresh your recollection? Or what would you say if I told you so-and-so testified? Or how would you, if we break this down into minute by minute, what exactly do you remember? Do you remember anything? You know what? I remember that I talked to this person. I remember I set up this, and I'm not telling them what to testify. I'm just saying, if I set up a GoFundMe to somebody, this is how I would testify. I remember setting up a GoFundMe. Do you remember having any conversation with him about the legality of what you were setting to GoFundMe? We might have talked about some legal stuff. I know he had a sponsorship, and he paid my husband some money to promote his product. Well, when your husband promoted the product, did the husband tell you that it was illegal? And that's another issue. We have husband and wife. They may be going after him through his wife and get his wife to testify on conversations that they had, but because there's a spousal privilege, she doesn't have to divulge that. However, you get into muddy water when it comes to, we're going to give you immunity, but we don't have to give your husband immunity. If your husband is committing crimes and you're trying to protect him in those crimes, you can lose your immunity. So, I mean, government has all the ways to do this. I do not think they want her to testify that she started a GoFundMe. That's it. I don't believe that. I think they're trying to get conversations between him and her that they had about whether he knew it was illegal, whether he promoted an illegal item, whether he advanced an illegal item through his sponsorship, and he advised this person on this illegal item and tried to encourage, assist, aid, or abet in the selling of these illegal items. If I had to guess, from my investigative experience, take a swag, a swinging wild ass guess right here, I would say that's where they're going with this. We're not going to get you on a stand because you can take the fifth. But if we get your wife on a stand under a ruse that she set up to GoFundMe, we can probably ask her questions about you. And if she says anything that incriminates you, we can then have probable cause to charge you. So again, without knowing his involvement, what the sponsorship, what they signed, what his advertisement was, without doing a whole bunch of research on this, I could be talking totally out my ass and not know what the hell I'm talking about. And I don't know what I'm talking about. But I want everyone to understand how the feds and how investigations work, how subpoena works. They were issued a subpoena. They were served in person. It's a federal subpoena, and they have to show up unless they can show the court why they don't think they should have to show up. a burden, a medical issue, a missed flight. I mean, we've had, it sucks, man. I mean, we've had witnesses come from out of state before that people have moved and we're working a case. And so you're usually, some agent is assigned to freaking witnesses out of state to say, hey, the DA goes, your job is to get this witness here. So we got to call them. We got to call them before. We got to make sure they're awake. We got to make sure they don't have any problems. If they suddenly go, well, I don't have any money and my ride didn't show up, then we have to call a taxi and say, okay, I got a taxi coming from you. We're going to pay for it. And then they go, well, you know what? I didn't eat breakfast and I'm really hungry and I got to stop. And, you know, and then we give them about. So you got to babysit them to get them there so they don't have an excuse for not showing up. So, and some witnesses, I mean, it's just a pain in the ass. They'll miss their flight on purpose. Man, I went to the bathroom and the flight left and I was trying to show up and I'm not trying to avoid you. And so now they're late and you scheduled a flight to where they're supposed to arrive and then testify an hour later. Now they're late. Now you got to go tell the DA, hey, witness missed the flight. The next flight's 3 hours away. He's going to be 3 hours late. And they're like, shit. And so if that was the last witness and they were going to close the case, now they're going to have to tell the judge, Your Honor, this is my last witness. It's 1 o'clock, but I can't call him till 4 because he missed his flight. The judge can go, you know what? It's your witness. You didn't get him here. If that's your only witness, then we're not going to hear him. Let's do closing arguments. And they lose it. And witnesses know this, and attorneys know this when they're advising witnesses. So I know they advise them to say, hey, you know what? If you miss a flight, you know, if it's unintentional, and they can't prove that you did it on purpose and you're late, then you know what? The trial will be over by the time you get there. And that way they can't charge you with contempt because you were trying to comply. So there's ways that witnesses can screw with cases. So I don't know how this is going to play out. It'll be interesting. But I talked to Matt and I told him I would advise him if he has any questions. He's got an attorney. Obviously, he needs to make decisions based on, you know, what his attorney tells them. But remember, attorneys don't face exposure. Attorneys don't have to worry about going to jail. Attorneys usually, I don't care how much they tell you they love you and they want to protect you and, you know, they're like the government. You know, cops are heroes. They want to protect you. Okay. Yeah. When you pay a lawyer, he's your friend. He wants to protect you. No, bullshit. He wants billable hours. He wants to keep the money flow coming and he wants to keep you kind of in the dark to where you need him. And he could give a shit if you go to jail. Matter of fact, if you go to jail, he's probably going to make more money on appeals and trying to get you out of jail. And he'll just milk some more money. So lawyers do not have skin in the game. That's good when they're defending you because they're not emotional. And usually if you get emotional, that's why they say don't defend yourself, because you have skin in the game. You get emotional, and sometimes that turns off the jury. Whereas if you have a neutral person argue for you that's not emotional, they come across as more believable, and they can usually represent you better. So I don't know what's going to happen in this case. I talked to him, and he's like, hey, maybe you could do a video on it and get the word out. So I did. And CRS Firearms, oh my God, it's on now. If you want to go research it, if somebody's been following him and has more information, you can put it in the comments. And the GoFundMe for this guy who, according to Matt, is kind of getting screwed. I think the ATF is always screwing anybody with guns. So anytime the ATF's going after anybody, I think it's crooked and it's probably some legal gun owner that they're just trying to attack. I mean, they don't go after the cartel like they go after legal gun owners. You know, if we have so much crime and there's so much gun violence and there's so much illegal guns out there, why aren't they going after criminals instead of good people? So anyway, I don't know anything about this guy, so I'm not going to say send him money or don't send him money. But if you want to find out about it, it sounds like he was either involved in making these cards, selling these cards, or whatever, and now the ATF is charging him. So we will end that there. And, you know, for those that think I did a bad job, can give me how I got it wrong in the comments. And we'll end that there. Y'all have a good one.